Good morning, ladies and gentlemen. First of all, I would like to express the great honor of being at this very important Congress. My name is TARSIS Barreto Oliveira. I'm a professor of law at the Federal University of Tocantins and the State University of Tocantins. As you know, data protection is a subject currently in evidence, not only in Brazil, but in several countries around the world, being an unfolding of the concept of privacy, which in turn is a right guaranteed in Brazil since the Brazilian Constitution of 1824. And the right to privacy is stated in the Brazilian Federal Constitution of 1988. And besides the Federal Constitution, there are several laws in Brazil that deal with privacy and data protection, such as the Consumer Defense Code, the Telephone and Telematics Interception Law, the Brazilian Civil Rights Framework for the Internet, which has in its text several principles related to the right to privacy, besides the law 13709 of 2018 itself, known as the Brazilian General Data Protection Act, whose main aspects I will comment from now on. Well, the Brazilian General Data Protection Act, which will come into force in August of this year, 2020, was created in order for Brazil to comply with the international requirements set in the General Data Protection Regulation of Europe. Regulation created, in 2018, and which has served as the basis for several rules of many countries, including Brazil. And as I said before, the Brazilian General Data Protection Act was based on the European model and seeks to ensure privacy without harming new business, especially those in the digital environment. And this regulation is applicable to any kind of data processing done in Brazil for public or private legal entities and also by individuals. The law also applies to foreign companies that offer goods and services to anyone in Brazil. I'll give you an example. If an e-commerce company in the United States offers its product to any individual in Brazilian territory, such company must comply with the Brazilian General Data Protection Act. However, the law does not apply to data protection done by individuals for private and non-economic purposes, and also for journalistic, artistic, and academic ends, for public security, also for national defense, state security, criminal infraction investigation, and prosecution activities. And data processing for this law refers to any operation that is done with personal data, such as receipt, creation, access, alteration, storage, transmission, and deletion. And this law, I'll explain you some items in the Brazilian Act, some terms, very important terms. The law calls data subjects all persons to whom the personal data are protected. It calls controller the the natural or legal person who defines how the data will be processed. Processor, it's the natural or legal person who carries out this data processing on behalf of the controller. There's another term, a National Data Protection Authority. It is the government agency that will supervise data processing operations in Brazil. And also, the law also calls data protection officer. It refers to the person appointed by the controller to act as a communication channel between the controller, the National Data Protection Authority, and the data subjects. Well, if a company defines how the data will be treated, but does not do the treatment itself, it will be considered a controller. If the same company hires another company to do the data processing, that company will be considered an operator. According to the law, both may have a data controller and both will be supervised by the National Data Protection Authority. I also have to mention the principles related in the Brazilian General Data Protection Act. The Brazilian Act sets out the principles, some principles that must be respected when processing data. So these are the principles. The purpose principle, first of all, which requires data to be processed only for specific, legitimate purposes. Also, the adequacy principle, which states that the data should be processed only for defined purposes. There is also the necessity principle, which states that only data strictly necessary for each purpose should be processed. There are also the principles of the free access, data quality, and transparency, which allows data subjects to have access to data processed by controllers and operators, to be able to correct such data when necessary, and to be clearly informed about the processing operations. There are also the principles of security and prevention, which require controllers and processors to adopt measures to prevent infringements of personal data. There is also the principle of non-discrimination, which prohibits data from being processed for discriminatory purposes. And the principle of accountability, which states that controller and processor must be able to demonstrate compliance with the Brazilian General Data Protection Act. Well, I'll now pass the word to Professor Cleovet Santos, who will continue the explanation of the main aspects of the Brazilian Act. And I'm at your disposal for any question, and thank you very much for your attention.